You know what? It's now time for a very important segment which we do every Tuesday morning at 8:05. We call it Constitutionally Speaking. And it's back this week in a big way as we'll be looking at the subject stiffer sentences for serious criminal offenses. To help us dissect this subject this morning, we're joined by the Deputy Public Defender, the Office of the Public Defender, well-known attorney at law, learned gentleman who has all the facts on this subject that you could desire. And so we're welcoming Mr. Herbert McKenzie this morning. Morning, Mr. Mack, and welcome. How are you?
I'm fine, thank you, sir. Thanks for having me again. Yes.
Welcome. Nice having you as always, and I look forward to our discussion. Over to you.
Yes. You know, over the last couple of months, we have been plagued with murders non-stop. It's only within recent times we have been hearing, based on police statistics, that the numbers are down by a certain percentage. Some of these percentages are small, some are significant to care about.
Yes.
But nonetheless, murder is still the top crime, and it's still one of the most prominent crimes in Jamaica now. But murder being the top crime, it's not the only serious crime. There are some non-murder crime, rape, and some of the gun offenses that are serious. So to help to create a deterrent, Parliament thought it fit to increase stiffer penalties, because it is thought that some of these people are almost going in and out of the correctional service. Like it's almost like a mill. You go in, you do a short period of time, and you are back out again. So your old bad ways.
Yes.
And against that background, Parliament passed 3 pieces of legislation. What they are amendments to existing law. But the intention of all 3 is to increase sentence and make sentences stiffer, with the hope that they might operate as a deterrent to would-be criminals and serial criminals, particularly murderers. So the 3 pieces of legislation they amend are the Criminal Justice Administration Act, the Child Care and Protection Act, and the Offences Against the Person Act. All 3 acts have to do with criminal offences and the sentencing. So the 3 acts sort of meld together insofar as the sentence is concerned to achieve consistency.
Yes.
Let's start with the Criminal Justice Act first.
Okay. Yes.
The amendment, as they call it, the Criminal Justice Amendment Act. The law is an amendment. Now, prior to the amendment, the law as it stood was that the term of life imprisonment was deemed to be 30 years for murder. So if you go to court and you're convicted for convicted of murder and manslaughter, and the judge say imprisonment for life, it's regarded for the purpose of calculating your sentence as 30 years. I'll let me tell you why, which is important for there to be a figure. Because the law has worked out a formula whereby if a person pleads guilty, a certain mathematical calculation can be applied for him to get a percentage discount depending on what stage of the proceeding he enters his plea. Okay. If he pleads guilty from the very first, he gets a bigger discount. I know that itself was a subject for discussion some time ago, where people were saying, you do this heinous murder and you simply go in and plead guilty and you walk with a slap on the wrist. No, for that purpose of that calculation was 30 years. Now, under the new law, that figure moves to 50 years. So if you commit most brutal murder, most heinous murder, and you go in the first day and you plead guilty, your percentage is not going to be predicated upon a starting point of 30 years. The figure is 50 years, 5 decades. So it is 30 years as a figure for which your percentage will be calculated. It's an offense which is not murder. So, for example, it's like a rape, like shooting with intent, stockpiling prohibited weapons, manufacturing firearm, trafficking. All those are the top offenses which are not murder. The figure for which a calculation is based is 30 years if it's not murder. So, in effect, loosely speaking, the Criminal Justice Amendment Act moves the minimum time from 30 years for murder to 50 years.
Yeah.
30 years for non-murder offences. Now, the Child Care and Protection Act, this is one now which has effect upon juvenile offenders, I should call them. Previously, under the Child Care and Protection Act, there was a scheme in which certain restrictions by law were set out for the punishment that can be meted out to juveniles. So, for example, you can't, if a juvenile did sentence, if it appears to the court that at the time at the commission of the offense, at the time of sentencing, at the time of the commission of the offense, he was under 18 years. And notice the law, it says that it appears. His age doesn't have to be proved. So you can have a lucky person who is old as he is, but he retains his age well, and when he comes before the court look at him and say, oh, the way you look, you could be less than 18. Then the court can the court should not impose a death sentence upon him. Mm-hmm. There's also a condition whereby life imprisonment, for life imprisonment on that person, the person cannot be kept at an adult correctional center if he's under 14 years old.
14?
Under 14. It can be if you're over 14 or not, over 14, but once you're under 14, it can be at an adult correctional center. However, the law has now changed, and what it has changed to, first of all, it has kept the non-death sentence. It has kept the non-imprisonment for failure to pay a fine. So, for example, you're charged for an offense and the judge fine you $1 million. If you don't pay the $1 million, normally you would have gone into prison for X amount of years. The law says you can't do that. So it has kept that in. Mm-hmm. However, this is where the changes occur. First of all, where the offense is murder and the person is under 14 years old, that person is liable to be sentenced to life imprisonment or a term of imprisonment not less than 30 years.
That's a major change.
It's a major change.
Yes.
But all is not lost, because even though the court throws him away for 30 years, the court can specify a minimum period, which that child will have to serve before he or she becomes eligible for parole. But that minimum period shall not be less than 15 years. So there's a little 15-year window, if you want to call it a window or escape route, or benefit that this juvenile can get. You probably can call it that.
Makes you wonder what the intended effect will in fact be.
What I think it is as a Jamaican, you would have realized that a number of these gun murders are committed by young men under the age of 17,
yes,
of kids under the age of 14, and it is not uncommon for police officers to be finding young boys, some of them under the age of 13, with gun in their bags, because quite a number of these adult male miscreants, use these youngsters to commit their acts, because youngsters are less likely to be suspected, or less likely to be searched by police, and more likely to enjoy sympathy from all quarters of the justice system. And some of them definitely are just mean-spirited young men whose value is such that they care very little, if anything at all, about life and limb. Now, if the offense for which this young person is convicted is other than murder, he can still get life imprisonment, but the judge hand is not tied to the 30 years. The judge hand can come down to the 15 years, and below the 15 years, make a minimum something below the 15 years, the time which he has to serve before he's eligible for parole. And all of that will depend upon the entire circumstances of the case and the antecedents and probation report of that individual when it comes to sentencing.
Sort of playing devil's advocate, I'm tempted to ask what are the sort of legal and human rights implications of increasing sentences for juvenile offenders under these new laws?
Well, they attract a lot of arguments.
Yes.
And a lot of the arguments based upon international law are that children are not supposed to be imprisoned. Children, by virtue of their youthfulness, are supposed to enjoy certain privileges that the adults don't. And the question you ask is a question that the human rights activists will always ask and will always advance, and will always use as bases for attacking the constitutionality of this piece of law before the Constitutional Court. That has not happened yet, so we are yet to see whether or not this new law can stand the constitutionality test when it comes before the Supreme Court. Now, there's another feature related to children that this new act introduces, which, based upon your question, will attract a lot of discussion from human rights activists. And it is the case where the child under 14 years old commits one specified offense. They call it a schedule offense, murder, treason, manslaughter, firearm offense. In that case, the court can sentence him to 25 years imprisonment, and he may be kept at an adult correctional center for the entire period. A child. That, again, is one of the things that is going to attract a lot of scrutiny from the people in the business of protecting human rights. Now, under the law, there is a provision that outlines what type of murder amounts to capital murder. And it sets it out. It's a whole host. You kill a juror, because he's a jury to a case. You kill a witness because the witness is a case. You kill a police officer because he's a police officer, a correctional officer because the correctional officer, a judge because he's a judge, a whole raft of things. Amongst that category of capital murder, and by capital murder I mean murder that tracks the death sentence. Amongst the categories of capital murder is one which states that where more than one person is found guilty of capital murder, but it is found that one or more than one of them did not use violence upon the deceased, or did not administer the fatal blow, or did not fire the shot, then that other person or the others shall not be guilty of the capital murder. Example, suppose A, B, C, and D went to, say, rob a bank. A was a man with a gun. A shot the security at the door. B and C grab money, jump in car, and all drive away. Those they are held, tried, and convicted. A would be liable for capital murder because committed in the course of a robbery. B, C, and D shall not be because they did not use any violence upon the deceased, or they did not administer fatal blow to the deceased. Now, under the laws that existed, the persons who are not guilty of a capital murder cannot be sent to the death gallows. No. Under the new amendment, if the child has attained the age of 14 years in a case like that, he didn't use any violence upon the person, he's not guilty of a capital murder, which is co-accused is guilty of, then he, that child, is liable to be sentenced to life imprisonment. And in that case, he can be convicted and kept at an adult correctional center. So for children, parents who have children who are running loose, take note.
Yeah, that's another major change.
It's another major change. Another major change which has attracted lots of controversy. The third act is the Offences Against the Person Act. The amendment, we call it the amendment to the Offences Against the Person Act, or short, the Offences Against the Person Amendment. Oh, I see time is on us. Let's put that out until next week.
All right, not a problem.
The Person Act, the amendment,
yes,
and its implications going forward.
We look forward to that discussion. I learned a lot this morning, as per usual, and I thank you so much for the time and the thoughts and the information you shared. Have a good one, Mr. Mackenzie.
Thank you very much.